to Senator Gavin. Senator Batchik, did you want to come in?
Yes, and just briefly to thank Senator Gavin for his words, and indeed to thank all colleagues across the floor and both sides of the House for their support for this bill, because of course it took support from all sides to ensure that it would reach report stage in government time. It is historic, as I say, because not many private members' bills traditionally have become law. So we very much look forward to this becoming law. We do very much welcome support of all colleagues. I should say that this is, of course, a long-standing Labour Party commitment this bill stems from, and indeed when we introduced it at second stage, my colleague Senator Nash, as Junior Minister, had a large part to play in its acceptance at second stage by government. But again, I do thank this Minister for continuing support for it and bringing it through report stage in government time. So very briefly, the amendments that the Minister has proposed, and which again we support, will provide for a new process for two groups of vulnerable self-employed workers to achieve exemption through application by their trade union to the Minister. And the first category is the fully dependent the first category, I should say, is the false self-employed worker. And this is somebody who is described as self-employed, but who in fact is in all but name an employee. And this is the category of worker in respect of whom the European Court of Justice had previously ruled in the Kunston case, which related to session musicians in a Dutch orchestra. And in that case, very helpfully, I think, the Court of Justice had set out a list of criteria by which somebody who is described as self-employed may in fact be considered to be falsely self-employed and in reality an employee. And I know that those are the criteria that are set out here in the Minister's proposed amendment in 15D. And again, I think that we very much support that. But there is a second category of worker, again in respect of whom trade unions will be able to apply for exemption to the Minister. And those are people who aren't captured necessarily by the false self-employed category. And we were very conscious that a lot of the people who had come to us, such as freelance journalists, for example, were would not come under the Kunston case, but rather would be better regarded as fully dependent self-employed worker. And again, we're grateful to the Minister and her officials for working hard. I know that drafting was perhaps more difficult because there wasn't a clear set of criteria set out in a court judgment, but I think it's helpful to know that it derives from ILO sources. And indeed, we see other countries like Germany where there is a similar sort of provision in place for somebody who, again, while they're described as self-employed, are in fact fully dependent on perhaps one or two persons for the vast bulk of their income, and indeed, as the Minister's amendment proposes, whose main income in respect of the performance of their services under contract is derived from not more than two persons. So I think that will capture a large number of people who have been really disadvantaged by the Competition Authority ruling. And I suppose then finally to say that of course the bill will also provide an automatic exemption, and this is very welcome, for a third category of self-employed worker, and that is those three groups who were previously specifically mentioned in the Partnership 2016 programme and who are now going to be listed in the schedule to the Competition Act as automatically exempt. And those are actors engaged as voice-over actors, musicians engaged as session musicians, and journalists engaged as freelance journalists. And I know we very much welcome that automatic exemption. I suppose just 3 points perhaps just to finish with on these particular amendments. I'm grateful to you, Minister, for outlining your intention to ensure that applications are dealt with speedily by yourself, or indeed by the Minister. I did raise with the officials the issue about a set time frame for decision making, but certainly we would anticipate, and I think the unions would anticipate, that the time frame would be that while it's not specified, that the Minister would act always expeditiously and speedily in coming to a decision in applying the criteria. So that's one point, and I know that the bill does anticipate again that the Minister will specify the manner for the application to be made. So it might be that, for example, we would see a guidance as to timing set out in that, and that I think would be very helpful for unions in making applications to you in future for exemption. So that's the first point. The second point is that I understand there's no prohibition on re-application by a trade union in respect of a class of self-employed, of relevant category of self-employed worker, where, for example, some conditions had changed, where a new group of individuals had come into membership in a particular union, and so on. And there's nothing in the bill, as it seems to me, and I'm sure you'll confirm that would prohibit or prevent a union from reapplying to you. And the third point, then, is the time frame for the bill's passage into law. And that, I'm very glad to see, is going to be dealt with in Amendment Amendment 5, where the Act shall come into operation no later than 3 months after the date of its passing. So I think, again, that's a comfort to the unions and all of those who've been engaged in this campaign for so long, to see that it will, we hope it will speed through the Dáil quickly, and I'm glad to see that there will be a commitment that it will be brought into operation no later than 3 months after the date of its passing. And I should have said finally that we have no difficulty, of course, with the deletion of Section 3 from our original bill, and I think I made that clear at committee stage.
Thank you, sir.